Hey everybody, welcome, welcome to Hidden Horror. Thank you for spending this time with me. I appreciate that. Let's get started. Hey everybody, welcome to Hidden Horror. How are you doing? How is everything going? Listen everybody, this video I do not want to do, but I gotta bring you the facts. I gotta come and I gotta tell you what happened at this April 9th hearing with Bryan Kohberger relating to his alibi. Let's think back. Now, we know that Bryan Kohberger, he really doesn't have a solid, provable alibi. I did a video some time ago about the alibi, about where Bryan Kohberger said he was. And it's a big problem. It was a big problem when I did. I said, hey man, they got you in this loop. It's not looking good for you. Where did you go? What were you doing? Did you make any stops? How can you account for all of this time, all of this driving? Where did you go? Did you get food? Did you get something to drink? Did you get something to eat? So check that video out if you're interested, because it's gonna filter all of these ideas out. But now I have to bring you up to date with everything. So we're gonna go and do a blast in the past to talk about Bryan Kohberger's alibi. We're going to talk about what's in Brett Payne's PCA relating to the movements of Bryan Kohberger. And then we're going to talk about what happened at the April 9, 2025 hearing, right? All of these motions discussed over a period of hours. And what does it reveal? I really believe we have some major problems with the defense, things we cannot overlook. We cannot push this out. We have to deal with it and deal with it directly, because from the initial affidavits that were filed by the defense as it relates to Cyray is an expert. He would provide expert witness testimony, right, in this Bryan Kohberger case to demonstrate Bryan Kohberger's whereabouts. For example, if Bryan Kohberger doesn't testify, it wouldn't really matter, because we would have Cyray and he would be able to go and demonstrate the movements, right? What was he doing? Where was he at? What time specifically, right? Well, we got problems now. We got major problems. That's not going to happen. I want to pretty much just get it out, get this ugly little problem out in the forefront. Cyray cannot testify at all to the time period. I believe it's about 2:47 a.m. when Bryan Kohberger's cell phone stopped reporting to the network through about 4:48 a.m. Let me check that time. And this is the time that's in Brett Payne's affidavit, and that is on page 13, okay? We're going to go over it all, but I just want to get this idea out first. And this is the basis of what is Cyray going to testify to. We have to think this through. We have to prepare ourselves. August is 4 months away, less than 4 months away. This trial is supposed to start August 11th, right? And we got major problems with Cyray's testimony. He's not going to be able to testify and say, I can demonstrate, I can show you, I can tell you the movements of Bryan Kohberger. In reality, this is, in my opinion, all of this is pushing Bryan Kohberger to testify on his own behalf. Cyray won't be able to do that now. He doesn't have someone that allegedly was with him during this driving, all of these stops, his movements throughout the morning hours. He doesn't have a witness. He doesn't have someone that's with him. Can he demonstrate through his stops? If he made stops, if he stopped to get gas, if he stopped to get food, if he went to an ATM machine, if he went to an all 24-hour store, would he be on camera? Would he be on video? What would help him demonstrate that, hey, not only was I not at 1122 King Road, that wasn't my car, I was here and I went here and I was there, because they have a time frame for the murders, and he has to find a way to demonstrate that. Now, we know that he doesn't have the traditional alibi. He can't give you someone's name and phone number to say, okay, you can be a witness on the defense side and you can demonstrate. He doesn't have that. But what does he have? He has to reach in, contribute to his defense, right? By saying, I was here, I was there, I stopped here, I took this path, I followed this way, I drove this way, I was there for this amount of time. He has to provide that information, because they're not going to allow Cy Ray to testify to that. They will allow Cy Ray, in my opinion, to testify up until 2:47 a.m. when they have his records, because he's on the network, and then after 4:47 a.m. and they're using those suspect videos, suspect video number 1, to show some continuous activity travel through this area where 1122 King Road is, and the judge is going to allow it. Can we say with 100% fact that's the same vehicle? No. Can we even say that it's Bryan Kohberger's car? No. Can we say it's similar in style, design, color? Yes. If it doesn't have a moonroof or a sunroof, I can't tell. The videos to me are very distorted, but I am not an expert. But you can't just pick any one. You have to say, this is Bryan Kohberger's car, not anyone's white four-door Elantra. You have to demonstrate, you have to show Bryan Kohberger's white four-door Elantra. Bryan Kohberger is in that car, is the driver or an occupant, right? It can't just be vague, okay? That's the issue. And the defense is going to have to hammer that down. Now, ways that they can do it, of course, cross-examination. They got the year wrong. The car cannot be clearly seen. They got the model wrong in the beginning. They were saying it was a Tesla. Does the car have a moonroof? Does the car have similar flaws like Bryan Kohberger's car? They're going to use that video of that stop from August 21st, 2022. I believe it's by the sheriff's office, when they questioned Bryan Kohberger at night as a traffic stop, to show you that white four-door Elantra of Bryan Kohberger's at night, and then they're going to show you these suspect videos, and that'll let you compare. Even though that's not what the video is being introduced for, that's what people are going to do. They're going to apply what they remember and compare it to Bryan Kohberger's white four-door Elantra. That's life. That's what's going to happen. So you need to anticipate that as well. But I'm bringing all this back to your memory, to your brain at the forefront, because we have to consider, what will Cy Ray be able to testify to? What is his value now? To me, it has been diminished. It has been reduced to pretty much nothing. He's an expert. He's an expert in his field. But Judge Stephen Hippler, he hit that question on the head when he said, Cy Ray, he did not address the 7-day window where you can get these records. If you can't get the records in the 7-day window, you didn't get the records in the 7-day window, how are you accusing the prosecution of withholding this information? How? What is your evidence? Why do you think this? How can you prove it? How can you show it? You can't just make things up. You can't just say things without no evidence, without no proof, without no facts, especially if it's really a negative way of doing it against the prosecution. He didn't like that. He made it clear. He has problems with the way the defense filed the affidavits of Cyree, and he's going to limit that testimony. And again, go back to my video a year and a half, whatever time it was ago, when I talked about going back to Bryan Kohberger's alibi, is going back to specifically, this is why the Idaho law is written the way it is so the prosecution can confirm, they can investigate the alibi. If you say you were here, you were with certain people, you were here for so long, they're going to contact them, they're going to put them on the stand, they're going to find out, can someone place you somewhere, and we can confirm it, okay? So it goes all the way back to the alibi, to it being specific, being able to be verifiable. And right now, we're facing the same issue. Cyree is really not going to have the impact that people anticipated. People thought he was going to really be able to exonerate Bryan Kohberger because of his knowledge and experience and demonstrate where Bryan Kohberger was. But in reality, it does not look like that's going to happen. So let's go back to the beginning. We have to go back to what was Bryan Kohberger's exact alibi. What did he say he was doing? We got to go back to that first. We got to lay that foundation. So we're going back to an article by rollingstone.com. It's titled, Bryan Kohberger's legal team says he was hiking and or stargazing the night of the Idaho murders. This was written April 18th, 2024, so literally a year ago, 1 year ago, by C.T. Jones. Kohberger's team claims this official alibi can be proven by cell phone tower data. Well, guess what? If you watch that April 9th hearing, it was a total beat down. They're not allowing that avenue to be discussed. They can only discuss 2:47 a.m. and prior, and then after 4:48 a.m. and prior. So that means that window where the murders occurred, Cyree won't be able to testify to that or provide any insight to that. And please, do you agree? Do you agree? Do you feel that is fair? If they don't have the time advance records from AT&T, which that was the network that the 8458, Bryan Kohberger's cell phone, they don't have those records. Do you agree? I agree. I agree with Judge Stephen Hippler on this one, because they made these explosive allegations that these records were withheld. But the reality is there were 7 days, a 7-day window where they could have preserved those records, or if they were able to go this other way, not through the GLDC, which that didn't roll out until May of 2023. We know the murder happened November 13th, 2022. So the GLDC process didn't roll out to the next year in the spring. So that backdoor, that other way, we don't know if the FBI did it or not. Judge Hippler said he will allow the defense attorney and Taylor to ask the FBI agent Balance. He will allow her to ask that question outside of the jury. But you know what? 9 times out of 10, we all know it's going to be a no, that they didn't have the records. Now, is that true? We will never know unless that evidence comes out later. But it has really diminished the power, the testimony we thought we were going to get from Cyree. It's diminished it. It's weakened it. It's pretty much taking him as an expert, and it's not going to be useful. Let's get to the article so we can lay the foundation of what Bryan Kohberger said his alibi was. He said, hey, I was out, I was driving, hiking, stargazing, etc., etc. But let's get it from the record, okay? The legal team for Bryan Kohberger, the suspect accused of the murder of 4 University of Idaho students, has doubled down on their claim that The 28-year-old was driving alone at the time of the murders and now say they have an expert who can prove it. Well, Mr. Syray, how are you going to prove that? Were you able to get those AT&T time in advance records? I have no idea. I don't know how you would prove it. And I don't think Judge Stephen Hippler is going to allow it unless you can prove, you can document, you can demonstrate. How did you get those records? Are those records accurate, valid? Okay. I have no idea. But how are you going to prove it? I don't think so. And Judge Stephen Hippler, he's not messing around. He's pretty upset at that hearing on April 9th, 2025. Let's go. Kohberger was arrested in December of 2022 as the sole suspect in the stabbing deaths of Kaylee Goncalves, 21, Madison Mogan, 21, Zaina Canelo, 20, and Ethan Chapin, 20. Four University of Idaho students who were killed in their off-campus apartment on November 13th, 2022. Kohberger, who was a graduate student at Washington State University at the time of the murders, was linked to the crime by DNA found on a knife sheath. And as I have said, attack the sheath, attack the sheath, attack the process, attack the IgG. How did they come to get that trace evidence, right? That touch DNA. You got to attack it, especially when we have better evidence like the other DNA that was found in blood and some under the fingernail clippings of victim Madison Mogan. Um, hey, alternative suspects, right? Well, let me continue. Was linked to the crime by DNA found on a knife sheath. In May of 2023, he was indicted by a grand jury on charges of murder. His legal team, held by public defender Ann C. Taylor, has alluded in the past that Kohberger had an alibi, right? Ann C. Taylor has alluded in the past that Kohberger had an alibi. Now, according to a notice request filed Wednesday, Kohberger's legal team has officially claimed the suspect was out driving to see the stars, and phone data can prove his whereabouts. After the school year began, Mr. Kohberger was busy with classes and work at Washington State University, and his running and hiking decreased but did not stop. Instead, his nighttime drives increased. This is supported by data from Kohberger's phone showing him in the countryside late at night and or in the early morning on several occasions. Now, this is interesting. The following reads. So if they have records that show that Bryan Kohberger was doing these runs late at night in the early morning hours on several occasions, maybe this is a different area. I don't know. But is this the same area where he allegedly went the night of the murders? Because that tells me that he is going to have some cell phone data in these areas, right? I don't know. Or it could be easy drop zones. I don't know. I'm not from this area, so I don't know how cell phone coverage is there. People can speak to that if they know, put it in the comments. The phone data includes numerous photographs taken on several different late evenings and early mornings, including in November, depicting the night sky. So they're trying to demonstrate that he has this habit of running, of hiking late at night into the early morning hours, and they have some records to prove it. They have pictures to demonstrate that on several different occasions, okay? The alibi filing adds that in the early morning hours on the day of the murders, Kohberger was out to hike and run and or see the moon and stars, a path they claim cell tower data expert Syray will partially corroborate in his testimony. The filing of Kohberger's alibi is one of the first steps in the long legal process the Idaho suspect will go through before his day in court. In August 2023, Kohberger waived his right to a speedy trial to allow his legal team more time to prepare. In December 2023, Kohberger's defense team was allowed to access the house where the murders took place and collect potential evidence. The house was then demolished to aid community healing, according to the university president, Scott Green, which we know now was a very bad idea. And I also did a video on that, not to demolish the house, but they did it anyway. So we can't do anything about that. It is the grim reminder of the heinous act that took place there, Green said. While we appreciate the emotional connection some family members of the victims may have to the house, it is time for its removal and to allow the collective healing of our community to continue. The family members didn't have an emotional connection to the house. The family members had memories of sending their kids off to college and expecting that their kids would be safe in this community. It has nothing to do with the house other than the value, the evidentiary value. Their connection was to their kids. I don't want to go there. Kohberger's trial day hasn't still not been set. Last year, state prosecutors announced they will be seeking the death penalty. So I'm just laying the foundation that in the beginning, when Kohberger submitted his alibi, it was stating that he was out driving. It was late into the early morning hours. He was hiking, running, stargazing. That was the sole basis of his alibi, right? Okay. So we're laying that foundation, okay? Now, excuse me, I want to go over Brett Payne's just a few things in his PCA because I think it's important. I don't like to tell you things without having factual information. I don't want to speculate a lot on this. So I just want to go over a few things. Um, the reason they knew Bryan Kohberger's phone number is because he provided his phone number when he had the traffic stop in August 21st, 2022, when he was in Moscow, Idaho. Okay, so they got his phone number from the traffic stop. They were able to get some records, okay, from his cell phone. And on page 12 of Brett Payne's PCA, I want to read one of his statements because they're building a foundation in this case, and it's really circumstantial evidence. But what's happening, if they can link enough circumstantial evidence together, it lends to give it more credibility. Okay, so this is Brett Payne's statement, and I'm on page 12, and I'm going to read it. It says, based on my training, experience, and conversations with law enforcement officers that specialize in the utilization of cellular telephone records as part of investigations, individuals can either leave their cellular telephone at a different location before committing a crime. For example, that means when you're going to go and commit the crime, you leave your cell phone in a different location. So, for example, leave your cell phone at home, then you go commit the crime, okay? Or, excuse me, turn their cellular telephone off prior to going to a location to commit a crime. So, you can leave your cell phone at home, for example, or right before you commit the crime, you turn your cell phone off, okay? And I've also heard you can put your cell phone in airplane mode, okay? So it says, I also know that on numerous occasions, subjects will surveil an area where they intend to commit a crime prior to the date of the crime. Depending on the circumstances, this can be done a few days before or for several months prior to the commission of a crime. During these types of surveillance, it is possible that an individual would not leave their cellular telephone at a separate location or turn it off since they do not plan to commit the offense on that particular day. So he's putting in this information for a reason. And the reason is he's really saying that all of the times that they can ping Bryan Kohberger's cell phone near the property 1122 King Road is because he didn't turn his cell phone off and he didn't leave the cell phone at home because he knew he didn't plan to commit the crime on that particular day. So it's going to surveil. Again, remember the idea of the stalking? That Bryan Kohberger allegedly stalked the victims. They later come and say that that's not true, but it lends to create that idea that All the other times his cell phone allegedly is found near 1122 King Road, that was for surveilling the property, surveilling the victims, watching them, seeing what they were doing. It's called stalking, really. So that's what he's indicating, that he didn't have a reason to turn his cell phone off during all those other occasions because that wasn't the time he was going to do the killing. But this particular day that the killing did happen, this is the day out of all these times that they have pinged him there or near the house. The time of the killing is the day that the cell phone is either turned off or put in airplane mode. Um, okay, that's what Brett Payne is saying there in the PCA. Now, I may go over some more stuff in the PCA that I found interesting. Um, I'm not sure. Well, yeah, I do want to go over another point that Brett Payne made. So on page 13, there's a paragraph that talks about the timing. And I want you to know that I'm not making this time up. I want you to know the timing for yourself. So it reads on November 13th, 2022, at approximately 2:42 a.m., the 8458 phone was utilizing cellular resources that provide coverage to 1630 Northeast Valley Road, Apartment G 201, Pullman, Washington, hereafter the Kohberger residence. So that's where Bryan lived, okay? His apartment there in Pullman. Now, notate the time, 2:42 a.m. Now, remember what I have always said to you. I have told you over and over again that what has always bothered me about this case is the last time that Maddie Mogerson and Kaylee Goncalves had any activity on their phone. Now, from reports, it said 2:52 a.m., but we also know that Maddie called Bethany Funk at 2:54 a.m. So we would just say about 2:54 a.m., okay? But around that time. But we know that at 2:42 a.m., Bryan Kohberger was still using cellular resources at his apartment, right? So again, this also gives me reasonable doubt. The defense should bring this up. They should hammer this idea in that Bryan Kohberger was at home. He was at his residence, and you know he was. Possibly Maddie and Kaylee were not killed at the 4 a.m., 4:30 a.m. time. Maybe they were killed earlier in the early morning hours when their cell phone stopped working. Both of them, no more activity on the cell phones, allegedly at 2:52 a.m. And I probably can read that in this affidavit as well, just to make sure you know where I'm getting that from. One moment, I will see if I can find something that has that in here. I can't recall if it does or not. My apologies. I just like to document things as much as possible. Okay, I can't find it in here. Wait, no, I can't find it in here. But what I wanted to read, and I'm going to continue, is at approximately 2:47 a.m., the 8458 phone utilized cellular resources that provide coverage southeast of the Kohberger residence, consistent with the 8458 phone leaving the Kohberger residence and traveling south through Pullman, Washington. This is consistent with the movement of the white Elantra. At approximately 2:47 a.m., the 845 phone stops reporting to the network, which is consistent with either the phone being in an area without cellular coverage, the connection to the network is disabled, such as putting the phone in airplane mode, or that the phone is turned off. The 845A phone does not report to the network again until approximately 4:48 a.m., at which time it utilized cellular resources that provide coverage to ID, Idaho State Highway 95, south of Moscow, Idaho, near Blaine, Idaho, north of Genesee. Okay, so we have the period between 2:47 a.m. and 4:48 a.m., about 2 hours, where Bryan Kohberger's cell phone allegedly is not reporting to the network. There's no cellular coverage, or the phone is turned off, or is placed in airplane mode. And I'm going to say allegedly, okay? I don't know what information Cyray has, what records he obtained, I don't know. But he was emphatically saying that he could prove that Bryan Kohberger was not near the murder house, 1122 King Road, or in that area. Okay, so I don't know what his records, his information has, um, but I'm going with what he put in his affidavit. Um, I can I can say, my apologies. I can say that from reading the affidavits, and I have two videos that I completed. I can share you if share my screen. If you've never been on the Hidden Horror Facebook page, please check my page out. Follow the Hidden Horror Facebook page. Um, I want you to know that all of the links, all of the videos that I share, the newspaper articles that I read, they are linked on the Hidden Horror Facebook page. And you can become my friend on here, and you can go back. You can refer to these links. You can refer to the videos. You can check it out right here. If I have an affidavit and I share it, it's right there. And in this instance, I did two different videos. I did a video on the AT&T timing records regarding Cyray's affidavit, and I also did a separate video that Cyray did, where he talked more about FBI agent Balance and his opinion of what documents he reviewed. Okay, so I do want to go over a little bit of the affidavit that Cyray he provided. Let me see if I can enlarge this a little bit. That he provided on Bryan Kohberger's behalf. So one he said that the expert testimony that was provided by the prosecution on behalf of FBI agent Balance, that the testimony was vague. That's what he determined. He didn't feel that he came to a lot of conclusions, that he couldn't follow his methodology. He had issues with that. And then he talked about the AT&T time in advance records. So I definitely want to show you the affidavit that he filed there. And, you know, he had some opinions. And he wanted to demonstrate to the court that there were basically two ways of getting these timing in advance records. One way was through the GLDC that was set up and that you could contact them and you could request those records. And that started in June of 2023. Um, but prior to that, there was another way that you could get records. In the FBI, they had a connection to get the records, obtain the records. And Cyril felt that that is what happened, that FBI, and I don't want to say specifically FBI agent Balance, but he believed that the FBI was able to attain Bryan Kohberger's time advance records and they did not provide them to the defense. Um, he felt strongly about that idea. He expressed that. He said that this was another way, this is a different way. Um, and he felt that they had the records and that they did not provide them to the defense because they would be exculpatory. They would demonstrate that Bryan Kohberger was not in the area or near the murder house, 1122 King Road, and that that was going to basically blow up the prosecution's case. If you give me those records and I review them, I'm an expert. I have been proven in this field. Um, I'm going to be able to blow up this case. Now, he did notate that other records were obtained from AT&T. There was a download of 3,800 mobile devices, um, but he never really addressed the 7-day window where they, at the time, would keep records. AT&T would keep records only for 7 days. The prosecution is saying that they didn't find out about Bryan Kohberger until December 19th, 2022. The murders were November 13th, 2022. We would not be in that 7-day window. And my first thought was, if you know you have a quadruple murder, would you reach out to all of the cell phone networks to say, can you maintain your database and preserve the cell phone data? Because we've had a major quadruple murder in our city and we're concerned about getting cell phone data. And I thought to myself, could they act as a courtesy to the cell phone companies to preserve the records for the 7-day window covering November 13th, 2022? And I know Ann Taylor did not raise that, but I did think of that. Could they reach out to AT&T? Could they reach out to Verizon, Sprint, and other major cell phone companies to determine if they found a suspect at some period that those records would still be preserved and intact? And Taylor, from my knowledge, have not addressed that, but I did think of that. But even still, Cyril, being an expert, felt that the FBI would have been able to obtain those records. Maybe as a courtesy, they would be able to go back somehow, or maybe they don't dump every 7 days like they say they do. You know, sometimes companies have policies, but they don't necessarily adhere to them, that they would have the records for a longer period of time, or as a courtesy, be able to go and obtain those records. Cyril thinks and believes this strongly, and I believe he thinks that for a reason. And on top of that, the FBI, they have some special relationships as a law enforcement authority, and maybe they would be able to get those records. And more particularly, especially if Bryan Kohberger was on the radar, his name was brought up back in the month of November. But Cyril is prepared to testify. And again, to me, this is definitely a battle of the experts, right? A battle that's going to be fought. And what will Cyril be able to testify to now, since Bryan Kohberger time in advance records, the prosecution is saying they don't have them. So let's listen to some of that testimony. So I'm going to share my screen. This video is provided by Fox 13 Seattle. It's titled Live Bryan Kohberger in Court for Hearing on Evidence He Once Thrown Out in Idaho Murder Case. I'm starting at about 5 hours, 14 minutes in. So I'm going to press play now and enlarge the screen so we can focus on the hearing.
As the court can tell from the numerous filings that have gone back and forth up in Latah County, that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. Talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because his phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant.
But let me pause it here. As I've been talking about Cy-Ray, they didn't say Cy-Ray name here, but Cy-Ray is the defense cell phone expert, and I believe they're talking about Cy-Ray at this point. Judge Hippler brought Cy-Ray up, so he's asking the prosecution, well, what about their expert? And what Cy-Ray said, he's going to testify. He's going to testify to where Bryan Kohberger was, his movements. And the prosecution is saying, well, how would they know that his cell phone was turned off? How can they rely on data that they should not have because it's past the 7 days? And again, remember, Cy-Ray did not address the 7-day issue in his affidavits. And please, the affidavit is on the Hidden Horror Facebook page. I did 2 videos on the time advance records and the affidavit. We're not going to go over that now, but that's what Judge Hippler is bringing up. They have this expert. He intends to testify to Bryan Kohberger's whereabouts, his movements, and prosecution is saying no. They're going back to this window that I told you, the 2:47 a.m. window to 4:48 a.m. window where Bryan Kohberger's cell phone is allegedly out of the network, turned off, or in airplane mode. So the prosecution is saying no, he will not be able to testify between that window where we feel the murders happened between 2:47 a.m. and 4:48 a.m., he won't be able to testify to his whereabouts at that period of time. He can testify prior to 2:47 a.m. or after 4:48 a.m. Yes, but in between that window, no. That's why I laid the foundation so we all can have the same understanding of what's going on and why I said we have issues, we have problems. Bryan Kohberger does not have any type of alibi that they can say where he was unless Cyril has some records that I'm not aware of, and of course the prosecution is clearly not aware of. How would he be able to testify to that unless he was able to obtain those records? And if so, how? How? When? What do they show? We need to know, right? The prosecution needs to know that information now, right now. They should have known this 2 years ago. If Bryan Kohberger could have been exonerated because he was not in the area, that should have happened after December 2022, if they knew that information. But to me, if they knew it, they would have demonstrated, they would have shown it, they would have gone to the judge, they would have went to John Judge, and said, we have information that's exculpatory. Bryan Kohberger was not in the area of 1122 King Road. We obtained his time in advance records that show he was in these areas during this period of time. We have mapped it, we can demonstrate it. We want to have these charges dismissed. That didn't happen. So now it makes me feel like they don't have the records. They don't have the evidence. It feels as if they made an accusation to the prosecution that they did and that those records would prove Bryan Kohberger's innocence, and that's why they hadn't turned them over to the defense. But the prosecution is standing on business saying, we never attained these records. We do not have these records. These records were never provided to us, including the FBI. And that's what it appears to me.
The defendant's phone was turned off. The defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There is nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the ability, the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was. But that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir.
Let me pause it here. Again, I agree with Judge Stephen Hippler here in the prosecution. If you have not provided an alibi, a witness at this point, the murders happened November 13th, 2022. It is April 9th, 2025. If you have not provided your alibi witnesses, people that can attest to you being with them, at this point, no. It is too late. It's too late in the game to try to confirm or investigate any type of alibi at this point. What you have is you have the expert, Cyril, that will be able to testify to everything leading up to 2:47 a.m. and after 4:48 a.m. But between that time period of the murders, no testimony from Cyril. Unless, again, there is some evidence that Cyril has that the prosecution is not aware of. I don't think so, everybody. I really don't think so. But please let me know what you think. I always want to hear your opinion. But Cyril to have written that, I don't know how he could have said that so emphatically if it was not true. But he is believing, I think that Cyril is believing that they have the records and they're unwilling to turn them over because they're exculpatory. But you have to prove that. You can't just state that as an idea. You have to prove it. Okay. Well, let's continue.
Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
Okay, I wanted to catch that. This right here is where I have a problem with Judge Stephen Hippler. Defense counsel is saying that he has maintained his innocence, that he was out driving. Pretty much, he doesn't have an alibi. He has no person that he had with him. He didn't go and see anyone. He doesn't have any way to prove his alibi, but he's standing on, I'm innocent. Now, Judge Hippler inserts himself and states, and he can testify. This is why I feel they're trying to force Bryan Kohberger to testify. But I want to tell you that he has a fundamental right. He has a Fifth Amendment right to not testify. And I want to read it to you. So I'm in Black's Law Dictionary. It's the 7th edition. It's an older one. The Fifth Amendment, the constitutional amendment ratified with the Bill of Rights in 1791, providing that a person cannot be required to answer for a capital or otherwise infamous offense unless a grand jury issues an indictment or presentment. 2, subjected to double jeopardy. 3, compelled to engage in self-incrimination on a criminal matter. 4, deprived of life, liberty, or property without due process of law. And 5, deprived of private property for public use without just compensation. Now they have something else. I'm going to see if I can find it here. Let's see. Says pleading the fifth. So I want to see if they have something in here for pleading the fifth. Pleading the fifth, the act or an instance of asserting one's right against self-incrimination under the Fifth Amendment, also termed taking the fifth. And really, it's your right against self-incrimination, that if you testify, you would incriminate yourself. So you have a right not to testify under the Fifth Amendment. So I don't like that Judge Stephen Hippler said that. It really bothered me. I don't know if other people that watched the hearing felt some kind of way. Please let me know. When Stephen Hippler just said he can testify to it, did that bother you? Let me know. Let's continue the video.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration. Now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on and 5, whatever it was, 4, so whatever it was,
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, so as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet.
Now, right here, we're going to veer off a little bit from the subject matter, which is the alibi and Ray's expert testimony, into the fact that there's so much evidence that she just hasn't gotten to. There's a large volume of information that she hasn't been able to go over and review. And her concern is she missing something that would help in Bryan Kohberger's defense. Now, as you see, you can look at the body language of Judge Stephen Hippler again. Again, how it comes across is very negative. Anyway, let's continue with the hearing.
If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now. But if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well, why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness.
Yes, sir.
Or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right.
Right here, the the prosecution is really honing in on this time frame where allegedly the murders occurred, and it's between that 2:47 a.m. and that 4:48 a.m. They're saying that, you know what, Bryan Kohberger, he concealed his location. We don't know. We can't prove where he was because he either turned off the phone, he was in an area where there was no cellular coverage, or he put his phone in airplane mode. But the problem is, and again, it's circumstantial, but it adds up. It adds up over time that this is the time frame allegedly the quadruple homicides occurred at 1122 King Road. And Bryan Kohberger, he can't account for his whereabouts. There's no alibi. There's no cell phone coverage to document and demonstrate where he was. But more importantly, this is alongside the timeline where the murders allegedly occurred. So this is why I say we have huge problems, very big problems in the case for Bryan Kohberger now that we know Cyre will not be able to discuss, talk about, demonstrate anything between that window of the murders, that time frame.
All right, let's talk about the AT&T stuff.
Thank you, Judge.
Excuse me. Now they're going to talk about the AT&T records and the fact that they don't have them, they never obtained them, and that, excuse me, the defense is making these allegations that they're withholding exculpatory evidence, which is not true.
This should be fairly simple. The state seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump, and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period. So the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window. So there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
The defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're
So
talking.
you're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
I have nothing further. Thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific.
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7.
Okay, here it comes, you guys. Judge Stephen Hibbler is about to get pretty upset about Ray, his affidavit, his accusation against the prosecution, and really the defense allowing it to happen without them addressing the 7-day window, the 7-day time frame that allegedly, that's all you had was a 7-day window to get these records from the date that you need them.
Day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that.
The other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
The 7 days that he's back home.
maybe.
I'll ask the state about those. If they receive those, I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did. And I would say their first search warrant was just a 48-hour period. It asked for timing advance records. But then the second warrant,
You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that. And here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were
records.
asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until I think about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you...
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he had supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put into any context the state had indicated and that provided AT&T sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
I'll tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
Okay, so you heard it yourself that Judge Hippler is saying that he's going to allow the questioning of FBI Special Agent Balance outside of the jury before the trial or at trial. So how likely is it that Special Agent Balance would say, yes, I have those records? Highly unlikely, right? But she needs to get it on the record. So if something comes out later, then she has it on record for a possible appeal or overturn. Of course, if the prosecution knows, of course, you know, it can lead to prosecutorial misconduct, disbarring, et cetera, et cetera. So, and Taylor is doing an excellent job of getting everything on the record. So please let me know what you think. Let me know what you think is left of Cyree now. You know, what is Cyree going to testify about now? They know, the prosecution knows where Bryan Kohberger was up until 2:47 a.m. and after 4:48 a.m. So how much value does Cyree have? I say Cyree value has been diminished. It's been really eliminated. He's really not needed as an expert witness. This really hurts the defense case. I don't know if Bryan Kohberger was considering testifying or not, but I don't know how you introduce evidence that demonstrates where he was between 2:47 a.m. and 4:48 a.m. if he doesn't have an alibi, he doesn't have a witness, he doesn't have someone he was with. Do they have video of him doing this driving? He sounds like he was maybe in a remote area in this Waikiki or Waikaka, whatever the name of it, park. That may be very limited area where they're not going to have a lot of cameras. A lot of people are going to be out in those late hours. And if they were, wouldn't they have come forward by now? Wouldn't the defense know? I don't know how much investigative effort they put into traveling the route that Bryan Kohberger told them he was on. Maybe they could obtain some video footage, some cameras. I mean, they would have had to do this in the early part of the investigation because it's 2025 now. Most people aren't going to have video from two and a half years ago. So hopefully they've done their due diligence. We will see, but this is a big issue for Bryan Kohberger, for his defense, for him stating where he was, because the prosecution is going to consistently go back to this time frame that they're saying the murders allegedly happened, and they're going to be able to say that Bryan Kohberger, he tried to conceal his movements, his location. That's where this is going, everybody. Tell me what you think. Thank you for spending this time with me. I really, really appreciate it. I want you to stay safe, stay smart, stay savvy. Be well, all my friends. Bye, everybody.